You let me know when you are ready, Judge Matojane.
I'm ready, Deputy Chief Justice.
Are you comfortable over there?
Yes, I am.
Okay. My goodness. You hold a number of academic qualifications, a BProc, an LLB, diploma in trial advocacy, 2 LLMs, and another diploma in corporate law.
Yes, Deputy Chief Justice.
And I see that you would have completed, well, almost all of them while you're already working.
Yes.
How did you manage that? Where did you find the time?
Chief Justice, remember when the new constitutional dispensation came into being, it was important for some of us to go back to school to study afresh constitutional law. And I did a master's by coursework in, I think it was criminal procedure, constitutional law, and evidence.
We are struggling to hear you. Perhaps
Yes.
bring your mic closer to you.
Sorry about that,
Oh,
Chief
that's
Justice.
better.
I was just saying in passing that after the new constitutional dispensation, some of us found the need to go back to school to sharpen and acquire new knowledge in constitutional litigation.
You started your legal career in 1992. No, it was before that. Oh, you did your articles of clerkship, then immediately became partner.
Yes.
You started your own firm.
No, I first did my article of clerkship for 2 years.
Yes.
Then thereafter started my own firm.
Was that a successful practice? How did things pan out?
Yes, as time goes on, the firm grew and it became, at one stage, I had 4 partners. So we're relatively busy.
And you remained an attorney until you joined the bench in 2010?
Yes, I think around 1995, I received permission to appear in the High Court, and I did a lot of appearances in the High Court whilst being an attorney.
And in these 12 years, you have also acted at the Constitutional Court?
Yes, I've acted first as a judge at the Land Claims Court, then I acted as the judge president at the very same court, then thereafter I subsequently acted as an acting deputy judge president at the Johannesburg High Court. I was also appointed as an acting judge at the Constitutional Court of Lesotho. I also acted for a stint at the Constitutional Court here in South Africa.
Yes. How long were you at our Constitutional Court?
It was for a term.
And you have, of course, acted at the Supreme Court of Appeal for
Yes.
a while now.
I have acted at the Supreme Court of Appeal for 6 terms.
Start there. When was your first acting stint?
Sorry, can you come again?
When was your first acting stint at the SCA? Do you remember?
I think October to December 2018.
And how have you found that experience?
I found it enriching. One was working with judges with institutional memory of many years, very intelligent, and it was interesting that, you write judgment, you are taken on appeal, you are either set aside or or upheld. Now it becomes different when you now have to sit in judgment over your colleagues, and I think the experience was enriching, I must say.
And how did your judgment, well, I know for a fact that you write quite well, you write good judgments. How did you square up against the senior judges there generally? Did you get positive feedback on your judgments, on your draft judgments?
Yeah, the interesting thing is you have 5 judges writing one judgment. You are a scribe, you circulate your first draft. All 5 of them are likely to comment and make suggestions. And you have a choice. You can either reject their suggestions or proposal, or you can incorporate their suggestions. This, in my view, strengthens the quality of your judgment. You cannot say, because I am a scribe, I'm going to be arrogant and say, look, I'm not open to suggestions. I learned that nothing beats experience. Just to cite an example briefly, we had a matter where I was a scribe. It was a very complicated matter. And the presider there, on the day of the hearing, identified one point that disposed of the whole case. When we got to court, counsel readily conceded, and the appeal was abandoned. I asked this particular judge, I could mention his name, Judge Nafs. I said, but look, I've been reading this voluminous record for this long, and you are able to pick up one point that disposed of the whole case. How do you do that? He said to me, look, this experience, I've been doing this kind of work for many years, this type of cases. And I imagine that if I had given him my draft after I had exerted myself, I mean, his depth of experience would have been such that that draft of mine would have been changed substantially. The point I want to make is institutional memory experience counts a lot and assists in strengthening judgments. So I do not see any problem in having a colleague strengthening my judgment, even to the point of changing it substantially, simply because I don't believe that there's a senior judge who would append his signature to a judgment he's not satisfied with.
Yes. Did you get an opportunity to write a judgment when you were at the Constitutional Court? I am aware.
Yes, I wrote a seminal judgment at the
yes.
Constitutional Court, class and another.
Mm-hmm.
It dealt with, I think, that case exposed patriarchy even in our court system. Mrs. Klasse lived in a farm as a seasonal worker for over 46 years. Her husband got into a fight and he was dismissed. The matter went to court. The landowner got an eviction order that evicted Mr. Klasse and all those who occupy through him, which meant that Mrs. Klasse was evicted arbitrarily. She wasn't afforded a hearing. Her circumstances were not considered, and she had children and grandchildren that she had to look after. The magistrate and the land claim court said that her occupation in the farm was through her husband, so she did not have agency. It wasn't necessary that she be considered. So I felt that our Constitution enjoins us to give effect to the rights that are enshrined in the Constitution, and that the ESTA has to be interpreted in such a manner that it's constitutionally compliant. So I concluded that she ought to have been joined in the proceedings so that her personal circumstances could also be considered.
I see that you managed to pull along luminaries such as former DCJ Museneke, Justice Cameron, and many others in that court, in that judgment of yours.
Yes, it was a very interesting academic challenge. Even at the Constitutional Court, you have 11 judges writing one judgment. They are not mere spectators who only correct grammars and put a tick there. They would come with proposals, even substantive proposals, and you must decide whether do you incorporate them or not. So it's not always a surprise if the first draft is completely different from the final product, because you have all these highly experienced senior judges also contributing to the writing of the judgment.
You have written a great many judgments from the High Court and in the other courts in which you've sat. How many of those did you write for the SCA?
For the SCA, I think I wrote about 7.
Mm-hmm. Were you able to get them delivered promptly?
Yes, they were delivered promptly in term, and at the High Court, I had a turnaround time of a week or 2 in delivering judgment. Yeah. For the simple reason that the Gauteng is a very busy division. Litigants want judgments, and if you put the judgment aside hoping that you'll have time to write a reportable judgment, it's not possible in Gauteng. It's just unbelievably hectic.
I see that you're also a member of the Women Judges Association. How did that come about? Are you a feminist?
Yes, I got to know of the organization, its aims, and its desire to crystallize the needs and aspiration of women judges and advance them. And I shared those ideals, and our local branch would send female law students to us that we mentor. They shadow us. And I found that to be invaluable, because some of us during our time, it was unthinkable to sit down and talk to a judge informally. So what I would normally do is, before going to court, I would give them a file just to go through. I remember in my case, when I finished my LLB, I had never seen a summons. So I would normally give them a file, go through it, we go to court, they listen to the arguments. After the hearing, we come back, we sit down, and we talk. So, in my view, that's another way of, showing these young and upcoming lawyers that everything is possible.
What do you think of gender representativity at the SCA? Are there enough women judges there?
Chief Justice Maya, it's, in my view...
It's Deputy Chief Justice...
Deputy Chief Justice.
Matojane,
let me
please.
Put it, in my view, diversity is not equal to representativity. In my view, maybe to give you an illustration, when I was acting as a GP at the Land Claims Court, I had occasion to attend the meeting of heads of courts. There was only one female judge, Monica Judge Leo. I think she is now retired. So it's all males. I got a feeling that this body, this deliberative body, is missing the diverse experience in law and social life of female judges. I just feel that when we talk about diversity or gender parity, the important point should be that women must also be heard. They have an experience to share. In deliberation, you don't have to agree with them, but hear them. There is just no reason why women should not be treated the same as men. In all my formative years at school, even at university, and even at the court, I've always had women beating me. I don't know why. I would always get position 2, and then it will be Dorcas who always got position 1. And
I think that's a common trend across the eons of time.
Yes, it's...
Judge Matojane, and there can only be one reason why they always come tops.
It's patriot.
It's not far to seek.
Yes, Chief Justice Mike.
I know this is an unfair question to ask, but I'll ask it anyway.
Yes.
We have 5 vacancies here and 11 candidates. 1, 2, 3, and 4. Only 4 of these 11 candidates are women. Now, I'm not saying that these women candidates are not as strong as the male candidates, but experience has shown that because women are still being disadvantaged, they're always at the bottom of the heap. They rarely get a chance to write quality judgments even when they do get to this level in the judiciary, that is. So more often than not, women are always, they will lag behind the men in terms of experience. Now, if you were sitting where I'm sitting and you had to make a choice, and it transpired that the women candidates were not as experienced as the male candidates, but unquestionably the potential is there, what would you do? Or maybe you don't have to put yourself in my shoes, just advise me.
Let me preface my answer by saying, if you have a tattoo on your face, you must want it. The point I'm trying to say is, Yes, I am for gender parity. Yes, I wouldn't really quibble if a female candidate is appointed over me. I would have no problem with that. The point I want to say is this job, no social life, nothing. You must want it. Whether you're a man or a woman, you must want it. So the answer to your question, Justice Maya, is I would have no problem in having a female judge appointed ahead of me, because in any event, that's a constitutional imperative.
Thank you for that.
Thanks.
Yeah. All right, I think this would be an opportune moment to hand over to my colleagues. You may start, Commissioner Maruma Khai.
Thank you very much, Thank you very much, Deputy Chief Justice. Good afternoon, Judge. I'm here.
Oh, sorry. Sorry, sir. Commissioner?
I've had the benefit of reading some of your judgment. There is a judgment that you wrote, which I really thought it was a very good judgment, on Section 8, subsection B of the Insolvency Act.
Yes.
Dealing with the nulla bona returns and all those things. I thought that was a good judgment.
Thanks, Commissioner.
But nonetheless, I just want to ask you about something that really has, ever since I joined this body, it has sat with me in relation to what is happening in the Supreme Court of Appeal. Yes. As a court. I realized that, and please just bear with me, I realized that the most recent case or judgment that was delivered by the Constitutional Court, it has about 44 pages, right? And you'll understand now as to where I'm going. And in that judgment, you have majority of the judges from that judgment are from the Supreme Court of Appeal, right? And it is written by the judge who was elevated from the Supreme Court of Appeal, Mhlantla. And you have Majid, you have Matopo, Theron, GT. All those are from the Supreme Court of Appeal.
Yes.
Now, having that information in line, there is a judgment that you wrote quite recently from the Supreme Court of Appeal. The Rada Meya versus Ferreira.
Yes.
You remember it?
Yes.
It's about 10 pages, right? 10 pages, the whole judgment.
Yes.
And the judgment that you wrote when you were at the Constitutional Court, that last judgment.
Yes.
That judgment is about 96 pages.
Yes.
And you wrote about 31 pages of that judgment.
Yes.
Now, my question is this. There is a view that when you are at the Supreme Court of Appeal, you write concisely, you write straight to the point, you get rid of things, right?
Yes.
So now, as a judge who was at the Constitutional Court, I'm not sure at that point if you are able to come up with, and it doesn't mean that when you write longer, the judgment becomes automatically good. And equally so, it doesn't mean when you are writing shorter, the judgment automatically becomes good, right?
Yes.
I just want to understand, what is this thing at the Supreme Court of Appeal in terms of this length of judgments, that when you get to that, because I've seen some of your judgments at the High Court, they are relatively longer.
Yes.
Why is it that when you get to that court, what is so special about that court, that the judgments of that court has to be of a specific length? And if they are of that length, then they are concise. Because in my view, the judgment that you wrote in the Constitutional Court, 31 pages, it's concise and it's well reasoned. And I agree with it fully. So that's the thing that I'm really struggling with to understand. Can you please just help me in that one?
Thanks, Commissioner, for your question. Personally, I believe that as judges, we write judgments for the losing party. They want to understand why they lost. And it doesn't help matters if you waffle and restate the common law, and instead of just being precise, to the point, and give the reasons for your judgment so that whoever lost would be in a position to can consider his or her position, decide whether he or she wants to appeal or to save money by not proceeding further with the matter. The appeal court wants your reason so that they can decide whether you are right or wrong. Coming back to your question, at the SCA, you get told that they've got judgment style. And if you don't follow that judgment style, believe you me, a lot will be said about you. Coming to the Constitutional Court, they also have their style. And you just have to follow that style. It's understandable in the case of a Constitutional Court because then they would have to start by summarizing the issues that were before the High Court, the SCA, and then they would then have to deal with the issues that are before the Constitutional Court. So in summary, the answer that I can give you is yes, at the SCA, they've got a style that you just have to follow.
Thank you very much for your honesty, because I think there is a serious disconnect. It cannot be that the judge in the High Court behaves in a particular way, yes, and then he goes to the Supreme Court of Appeal, is expected to behave in a certain way. Yes. Then that judge goes to the Constitutional Court, and that has to disregard everything that happened at the Supreme Court, yes, Supreme Court of Appeal. I think there is a serious disjointment that needs to be really taken. But it's fine. I wouldn't take it further than that.
Thanks, Commissioner. And maybe just to add on what you've just said, Commissioner, it would be ideal and it will help in the transfer of skills if you can be told there and there that your judgment is terrible, your judgment. I mean, what's the point of not telling me that I can't write the judgment at this stage? I mean, you have a presider, is a senior judge, highly experienced. He's quality assuring your judgment. And if he sees that you are lost, you don't know what you're doing, what is that senior judge's responsibility if he genuinely wants to transfer skills to an acting judge?
Thank you very much.
Thanks, Commissioner.
Thank you, DCJ. Good afternoon, Judge. I'm just next to you.
Yes, thanks, Commissioner.
Firstly, my first question is just a follow-up to your debate, your discussion with the DCJ. For a judge who seeks appointment to the SCA,
yes,
and a judge who seeks appointment as a judge to the High Court,
yes,
would you agree with me that we should actually apply a different standard in respect of consideration of these candidates? Because in respect of the judge for the High Court who applies for the High Court, definitely we have to look onto the potential of this candidate, whether does she have a potential, taking into account the fact that it's coming from practice, acting judge and so forth. For the SCA, there's somebody now who comes because that court is a national appeals court. That's a national appeal court, and it must, in a way, settle the precedent. It must develop the law, because it's just from it. It's just a constitutional court. From there is a constitutional. So what would you say on that?
Commissioner, I would say that there is no substitute for experience. If you are inexperienced, you do the heavy lifting. And I remember when I was writing this classic judgment, Judge Cameron said to me, have you considered such a case? When I went to look for that case, it was his judgment as a judge in the High Court. I mean, this person started at the High Court, she was senior counsel, judge at the High Court, judge at the SCA. He's now at the Concord, and you are sitting in conference. So, for an inexperienced judge like me, you had to read everything. For an experienced judge like him, I mean, he just suggests you, have you considered such and such a judgment? Have you, in most cases, you find that he has written over that topic. He knows everything about it. So the point I'm making is this, that you can have a senior counsel, highly experienced, who can go straight to the Constitutional Court. You can have a highly experienced SC who doesn't belong in the High Court. So I don't have a specific answer, but the point here is this august body has to decide, based on the judgments of a particular candidate, whether this person has acquired sufficient, if it's in the case of an SCA, general knowledge of the law.
Yeah, my last question pertains to this debate with the Prof here, about the length of judgment, stance in the court of judgment. Is it not that at the level of the High Court, for instance,
yes,
where at the High Court, it's where you will hear evidence, witnesses there, and then the first judgment comes. And when you appeal, issues get crystallized, they are narrowed. By the time you get to the SCA, the issues are so pointed such that you won't be rewriting the entire evidence because issues have crystallized, you have a judgment in front of you. That's the first point.
Yes.
That in respect of the length of that judgment. I'm just thinking. And then in the Constitutional Court, obviously you start with the application for leave to appeal. You have to determine issues of the leave to be granted and other issues. And that's the final court of appeal. It has to define the issues that, would we really expect this court to write or to have judgments which are similar in nature, really? Would it be surprising that the judgment at the SCA would be short, precise, at the SCA would be have lengthy judgment, you have 11 judges involved, and with all those applications that comes in between?
I don't know if I understood the question, but what I can tell you is I was a court of first instance in that all-pay, the so-called SASSA matter. It's one of the biggest tender to be awarded by the government. The tender was flawed, and I declared it unlawful, and I couldn't set it aside, for the simple reason that I was told that to reconstitute the bids, to re-adjudicate this tender, it would take 3 years to reconstitute the bids adjudication committee because senior people in government, Director General. So it meant, had I cancelled that contract, it meant that pensioners were not going to receive their grants. Children-headed families were not going to. In fact, there would have been a revolution had I set that contract aside. Now, when the matter came before the SC, I remember I was set aside, and the matter went to the Constitutional Court, and ultimately the Constitutional Court granted the structural integrity. The point I want to say is the issues that were before me, by the time they went to the SC and they were now refined. In most cases at the SC, you have senior experienced counsel who'd really made concessions They wouldn't just argue a point for the sake of arguing it. And they're helpful to the court. They would make you aware of judgments that does not even support them. So issues get narrowed, issues get defined. And I mean, when I read the judgment of the SC and the Con Court, the issues being debated there were not before me.
Thank you, Judge.
Yes.
Yeah.
Thank you, Commissioner Nakiesi. Commissioner Malema.
Thank you, Acting President. Judge, I just want to understand what is your understanding in terms of why our prison system is called correctional services?
I think the idea is to try to reform offenders. Hence, even the language, they're not called prisoners and all that. They would refer them as I think the whole idea is to rehabilitate with the intention of reintroducing these offenders back into society.
So in the rehabilitation of these inmates and reintegrating them into society, what will the society benefit if we were to incarcerate an 8-year-old, rehabilitate and integrate into society? Because by the time he gets back into society, there's no longer a human being there.
I think you're asking a very good question, Mr.
There remains.
You're asking a very good question, Mr. Malema. But my answer to you is this, that you should understand the nature of our work as judges. Parties bring their dispute to us before court. Parties have legal representation who formulate the issues, who would refer you to authorities, decided cases and all that. And then, much as you have a wide discretion, you can't go beyond what is before you. You can't go on a frolic of your own, do your own little research on the corner there, and put it in a judgment because you think that is right. Your hands are tied in the sense that you are called upon to discuss a live issue. You are not called upon to speculate. You cannot, I mean, the question that you are asking me is really hypothetical. And the nature of my job is to hear evidence, be open to persuasion by counsel on both sides, research the law, and make an order in line with the arguments that have been presented before me. If I want to do my own private research, I must invite the lawyers to make supplementary heads, deal with what I think is a correct position. So, in short, Mr. Malema, the point I'm making to you is this, that as judges, we do not deal with hypothetical cases. Cases are fact-specific. You are guided by the facts of the particular case, the arguments that is presented before you, and then you are able to write the judgment.
But Judge Matojane, part of your responsibility as a judge is to take into consideration the budgetary issues, the interest of the country. I'm asking it, hypothetically, because I don't want to get into trouble. The last time you were here, I asked you a question, I got into trouble.
You want to get me into trouble also by asking hypothetical questions.
And I was alone. So I'm trying to think, because objectively and subjectively, all those factors have to be taken into consideration, that ours is to correct and reintegrate. And if you bring a frail, sick, old man before me and you want me to imprison, even if the facts are like, I can hear you, you're correct and all of that, it is in the best interest, is it in the best interest of our society to incarcerate old people who are not in line with what correctional service system seeks to achieve, which is rehabilitation and reintegration into society?
My short answer to you, Mr. Malema, is this: that you want to get me into trouble by giving an opinion on a hypothetical set of facts. And I'm saying to you, as a judge, I don't go out, look for cases and bring them before me for adjudication. It is the parties who come to me with their dispute, and my job is to adjudicate. And secondly, I know where you are going with that question. That matter is pending before the Supreme Court of Appeal. The lawyers use the term functus officio. I'm out of it. Whether I'm right or wrong, a higher court is going to relook at the evidence, and then they'll decide. If I'm wrong, they'll say so. So it's not really for me to answer that question, Mr. Malema, with due respect.
With due respect, Judge, I don't know which case you're talking about, because I'm talking about correctional, because we moved from prison system to correctional system, from prisoners to inmate, with the objective of exactly what I was saying. But if you are uncomfortable, it's okay. I'll leave it there. But because I'm worried, acting president, that what type of society will we become in line with corrective measures to imprison elderly people who are not going to benefit anything from them? Because if we invest, correctional system, in my understanding, is to invest in this person, rebuild this person, and take this person back to society to continue to contribute positively into society.
Yeah, but Mr. Malema, are you not raising that in a wrong forum? You are a public representative. You are elected to Parliament to go and make laws.
Yes.
This is an issue which, in my view, you should raise in Parliament.
You also make laws.
Judges don't make law.
There's case laws you make.
Mr.
Judges
Malema,
who are scared to make case laws are cowards.
Okay, let's see what the Constitution says.
That I appreciate, but I'm saying you make case laws. That's why there's always case law referred to by many others, including ourselves.
Malema,
Commissioner
Malema, I'm sorry.
No, you can say Malema, I'm too young to you. You can call me anything you want to call me.
What I'm saying...
Excuse me, Judge
yes,
Matojane. Commissioner Malema, please be mindful. We reiterated before our lunch adjournment that commissioners must please confine themselves to the conventions of the commission. You are allowed 2 questions, and that's it, other than follow-ups. I think you have now exhausted your questions.
No, I raised one uncomfortable question, and I'm ready to leave it, because I can see you're also becoming uncomfortable.
I didn't get that, Commissioner. Are you done?
I raised one uncomfortable question. I didn't raise too many questions. I didn't raise 2. I raised 1, but I'm saying I can see you're becoming uncomfortable with it. I'm ready to let go of it.
Please, if you don't mind. Thank you.
Okay, thank you, Acting President.
Thank you, Commissioner. Commissioner Matojane.
Thank you, Acting Judge President. Good afternoon, Judge Matojane.
Yes, I can hear you.
Good afternoon, Judge Matojane.
Good afternoon, Commissioner Lepo.
I've known you from the BLA when we were still young.
Yes.
Yes, that's why I'm declaring. And mine is just a comment. You know, you are very meticulous in your training, trial advocacy, and I really sometimes admire you.
Yes, I'm passionate about
Yes, but
trial
and
training.
you've got so much experience, commercial law, and you know. What I just want to find out, why don't we attract people of your caliber to go competition?
To do what?
To the competition court or the land claims court? Why would everybody want to go to the SCA? Why is it not appealing or what? The competition commission court? The competition court or the land claims? I just want to find out, yeah. Is there anything that doesn't attract people to go there?
With the land claims court, I do know that there was uncertainty for a long period of time. There were no permanent judges. It's now that permanent judges are being appointed to that court, and I want to believe that it's going to be fully functional, and advocates and attorneys would get to know that court and what it's all about. And then you're referring to the other court. Which one was that? The commercial court.
Competition appeals court.
Competition appeals court. Oh, I'm speculating here. That could have to deal with briefing patterns. I remember my second master's was in competition law, because I mean, then would do divorces, array of matters and all. I wanted to get into that field, but you would know how difficult it is. I mean, conveyancing was ring-fenced. If you were not of the right color, you wouldn't get conveyancing work. Now, the government really, are they briefing black people in competition matters? I mean, I did this matter of ComAir against SAA. That matter was argued for 45 days every day. And they had a running record. Overnight, you'd get a transcription of the proceedings that took place the following day. The counsel who were appearing before me started the matter at the commission. The matter went to the tribunal and to the competition appeal court. When it came to me, it was for quantification of damages. I tell you, all those counsels were unbelievably good. They knew the facts, the issues, as they knew the back of their hands. I don't take it away from them that they were capable, highly experienced silks, but the fact of the matter is they started with this matter at the commission, tribunal, appeal court, and when they came before me, I tell you, the matter was voluminous. I mean, there were over 100 Acliver files. Witnesses were brought from London to come and testify. Everything was technical. The various experts that testified there also testified from the commission, tribunal, appeal court. So if it's easy to think that you would never reach that level, you have to be a genius, you have to have, I mean, exceptional abilities. In my view, given a chance, even puny judge like me, if I had started with a matter at the commission, tribunal, appeal court, when I come to court to argue quantum, I think I'll excel. The point I'm saying is opportunities. Do people have opportunities to acquire the necessary experience and expertise?
Thank you.
Follow up, CJ.
Yes, you may proceed, Professor.
Judge, Judge Matojane,
Yes.
I'm here.
Commissioner. Yes, okay.
Yes. I think the question that was asked was, as a judge, why do people of the capabilities that you have will opt to go and be presiding officers at the Supreme Court of Appeal, as opposed to the Competition Appeals Court and the Land Claims Court, or even the Labor Appeal Court, perhaps, which I'm just adding there. Because those are specialized courts that can use people with your ability. I think that was the question, not necessarily from the practitioner's point of view and the opportunities that people get.
Yes. Speaking for myself, with my master's in competition law, why am I not applying to the Competition Appeal Court? I never got briefed in that field of work. I only have the academic theory. I don't have practical exposure to that type of work. So I think I'll fail if I can apply to be a judge at the Competition Appeal Court.
Thank you, AP.
Thanks,
Thank you,
Commissioner.
Professor Muramukhai. Commissioner Nyambi, or have you been taken care of?
No, I've been taken care of, Acting President, I'm fine.
Thank you, Commissioner Nyambi. Commissioner Muiman.
Thank you, Acting President. Good afternoon, Judge Matojane.
Good afternoon, Commissioner.
Just two areas from my side. What is that could be done to make the public aware of the provision of Section 165, 1 up to 3, that talks to the vesting of the judicial authority of the Republic in our courts, its independence, and also its impartiality vis-a-vis the positioning of the courts with regard to the role that they play in instances where there is a disregard to the values of the constitutions, amongst them the rule of law, the need for all the other arms of state to act impartially, to act rationally, to ensure that all the decisions that it take are in line with the Constitution, because Section 2 of the Constitution also talks about the supremacy of the Constitution, meaning that any conduct that is in conflict with the values in our Constitution through Section 165 grants the court the discretion to set aside those decisions. Yes. Thank you, the President. Thank you, Justice Matojane.
Thanks, Commissioner. I must say, you are raising a very pertinent, good question. Section 165, sub 2 of the Constitution reads, the courts are independent and the law, which they must apply impartially and without fear, favor, or prejudice. Judges are expected to have independent mind. How can I put it? The Constitution enjoins you to apply, to protect the Constitution and the rights embodied therein, without fear, without favor, without prejudice. You cannot be aligned to a political party or an interest group and still be independent. Independent presupposes that you would enforce the Constitution irrespective of how powerful or how influential a particular person is. Now, the rule of law, implicit in our constitutional offering, is the principle of legality. Public power should be used for the purpose it was granted for. Any law that violates the Constitution is invalid because the Constitution is the supreme law of the land. Whether you are a president or a gardener, you are subject to the law. If you are a public official, you have to act within the law. Now, interpreting a constitution is political in nature. There will be those tensions because a politician will say, I'm a public representative. I have a mandate from my constitution. The government will say, this is our policy. Now, as judges, we are not public representatives. We are not elected. We are appointed in terms of the Constitution to give meaning to the socio-economic rights that are in the Constitution. So that will definitely create tension. If you are a politician, you would want appointed a judge that will be sympathetic to your cause or constituency. Or if you are an interest group, or for want of a better word, you don't want a judge who is independent and who will, without fear, favor, or prejudice.
Thank you,
Thanks,
Matojane.
Commissioner.
Thank you.
I
President.
hope I answered your question.
Yes, definitely. Thank you.
Thank you, Commissioner Amwimam. Commissioner Pillay.
Thank you, Acting President. Good afternoon, Judge Matojane.
Good afternoon, Commissioner.
Judge, in your form, when you are asked to list your most significant judgments,
Yes.
At number 2, you mentioned the DA versus Minister of Cogta matter.
Yes.
Which was the constitutional challenge to Section 27(2) of the Disaster Management Act.
Yes.
And you mentioned that that's one of the most significant judgments, even though it was a dissenting judgment.
Yes.
I just wanted to ask you a question about that judgment, because what was striking in that case was that the majority took into account the fact that when the minister declared a national state of disaster under the Act,
Yes.
she did so in circumstances where it was unclear or uncertain what the nature of the disaster would be.
Yes.
And in fact, no one in government at that stage would know exactly what it is that they're going to be dealing with, because this happens right at the onset
Yes.
of a disaster. And the court also took into account that a disaster being what it is, there would be a need for government to be able to act effectively and expeditiously
Yes.
in order to arrest the disaster.
Yes.
Now, those were the two central issues which the majority took into account in deciding that Section 27(2) could withstand the constitutional attack.
Yes.
Now, you, on the other hand, you in your dissenting judgment found that there was an excessive delegation of legislative power
Yes.
to the minister.
Yes.
And you then say that you would have declared the section unconstitutional and you would have remitted it to Parliament and have Parliament cure the defect in a certain period of time. I think you mentioned 2 years.
Yes.
Now, what was not clear to me reading your judgment, and if I was a parliamentarian who had received this, let's assume you were the Constitutional Court, received your declaration of invalidity, and you're now expected to cure the defect, it wasn't clear to me how you envisaged that defect being cured, given those two central issues. One, that it was impossible to predict in advance the nature of the disaster, and two, that there was a desperate need for government to be able to act efficiently and effectively.
Yes. Commissioner, your question is multifaceted, and it's a good question. The point I want to make is, you're right when you say a disaster cannot be predicted. We can have locust infestation overnight, and draconian measures have to be put in place on an urgent basis. But my point, my concern here is, up to now, I don't think the minister has placed that before Parliament so that Mr. Malema here can make an input as to the desirability or otherwise of banning people from buying cooked chicken, stopping people from running in the morning. The point I'm saying is, yes, the minister may have to act with expedition and take urgent measures, but what stops her thereafter from going to Parliament and explain herself and invite input from other parliamentarians? I mean, up to now, there hasn't been, I'm not sure whether there has been any legislation that came out since you remember, at one stage, every month, the state of disaster was being extended with no debate in Parliament as to the desirability or otherwise of further extending the state of disaster. I mean, the minister had such wide excessive powers that even overrode other legislation. We have the Liquor Act. She had power to control the sale and drinking of liquor. So my point was that you can't delegate excessive power. You see, in a democratic state, we could have the next government. Maybe AfriForum is in power. The EFF it's a government of the day. Now, if we don't seek to regulate government power, if government can, delegate wide powers, unchecked, we are creating precedents would have difficulty in following. In summary, the point I'm trying to make is the role of Parliament is to have the public representatives deliberating and passing legislation, rather than giving the minister the power to legislate uncontrolled and unchecked.
The only point to raise, Judge, is that not only the majority in this case, but a number of courts, ending up all the way in the Constitutional Court, have recognized the imperative for the executive to have those powers in a disaster,
yes,
a national state of disaster, because of the unique nature of a national state of disaster, and specifically the COVID pandemic which we dealt with,
yes,
which was inherently uncertain and unknown.
Yes.
That was the difficulty that we were dealing with.
Can I come in?
And that the principles that you espouse are principles which ought to apply and and should be upheld, but almost in an ideal situation.
Yes.
But not necessarily
before
in a
you move
disaster.
further, can I come in there? The point here is, yes, the minister should have those powers, but she must account to Parliament. After, we can have an earthquake today, maybe in the next week or two, let her come to Parliament and have that issue debated and the relevant legislation passed.
Thank you, Commissioner Pillay.
Are there any further questions, Minister?
It's just a follow-up on that. Firstly, Judge, I agree with Commissioner Pillay that this...
Sorry, Minister, can you repeat that?
I'm saying, firstly, I agree with Commissioner Pillay that these powers were necessary for any eventuality in cases of disaster.
I also agree with her.
Yeah. And I also think that there is a platform to account. You will have, I heard you saying you are not aware, but several ministers responsible for some of those powers were called to their portfolio committees to account in terms of the exercise of these powers.
Did they account in Parliament?
Yes, in Parliament.
Yes.
They were called, including the Minister of Cooperative Governance.
Was legislation passed?
Obviously, they were invited in terms of this legislation that there is these regulations that we are dealing with. What are the issues? The political parties hold them to account. The biggest debate was whether there should be an ad hoc committee and all those kind of things. But they were called as executive authorities by their various committees to account.
Yes.
So I'm just raising that the act is not as wide as you, I hear you to be saying that it's an unchecked kind of exercise of power by the executive.
Thanks, Minister.
Judge, I'd just like to point out that legal commentators worldwide have commented on the dangers inherent in the powers given to the executive during times of emergency and the way in which they potentially threaten a democracy, a constitutional democracy. So while I certainly agree with a lot of what my fellow commissioners have said, I would commend you for raising the issue because it's something that as a democracy we need to watch closely.
Thanks, Commissioner. Just a short comment. During apartheid, they would govern through these regulations, and okay, maybe let me withdraw that. Thanks, Commissioner.
Commissioner Bernard, do you have a question for Judge Matojane?
I do, DCJ.
Go ahead, please.
Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes, you have an experience as a conveyancer. Is that correct?
Yes.
And what is the benefit of having former or people with conveyancing experience also as part of your SCA judges?
Yes.
We heard there are some others earlier in the week, including the acting president, but you would be one of those if you were to be appointed. So what is the benefit?
Conveyancing is a specialized field where you have to acquire expertise in property law, interstate succession. You know, all these laws comes into place in a conveyancing transaction. Huge amounts of money are involved, and knowledge. Let me put it like this: every law relating to property you have to acquire knowledge and expertise in every law that relates to property. So my knowledge of conveyancing, in my view, would add value in any matter involving property law. For instance, I wrote a judgment where an entity designed a software that was to basically automatically populate the platform with all the information that, in terms of the law, should be prepared by a conveyancer. And then they were saying they will employ conveyancers whose job will be just to append their signatures to the documents that would have been automatically generated. And I felt that because of you need to know deceased estates, you need to know the law of intersection, the law of succession, you need to know the wills. You cannot have a non-lawyer doing the work of a conveyancer. It's a specialist field. They took the matter to the SCA. The SCA agreed with me. They went to the Concord. The Concord refused them left to appeal.
You're referring to Property Smart versus Law Society?
I didn't catch that, Commissioner.
No, so thank you. I think you're referring to Property Smart versus the Law Society.
Yes.
Thank you very much.
Thanks, Commissioner.
Thank you, DCJ.
President Pedro.
Thank you, Deputy Chief Justice. Judge Matojane, we've had a long day and there's still a long way to go.
Yes.
I've got a few questions for you. You acted at the SCA altogether for 6 terms.
Yes.
And when it comes to judgments, you'd know that the scribe is not obliged to accept comments or suggestions from the other colleagues.
Yes.
But nevertheless, you would give serious consideration to them.
Yes, because in most cases, these are highly experienced senior judges.
Thank you. Then the last one is just an observation from the comments received from various professional bodies and lawyers' organizations.
Yes.
All of them attest to your scholarship industry, delivering judgments promptly and extensive professional experience.
Yes, I've noted that and I'm grateful for that.
Thank you. That's where I leave it.
Thanks.
Thank you, Deputy Chief Justice.
Thanks, Acting President.
Anything you would want to bring to our attention, ask us, address us on before we let you go?
Well, it's just a plea with respect that the commissioners should bear in mind that we are sitting judges. I may be in court tomorrow, and if I'm to avail myself for this process and get humiliated, what are we saying to the parties who are appearing before us? That's how far I can put it. The point I'm trying to say is this, that has a decisive impact on the rule of law, because you want litigants who appear before you to have confidence that their matters would be ably and properly adjudicated upon. But if in this platform it is insinuated that I don't know what I'm doing, why should a losing litigant accept that he or she was unsuccessful in that matter when that litigant knows that I don't know the law? It's just a plea that commissioners should bear in mind that we have families. As judges, we have developed thick skins. If you go on Twitter and see the kind of things that have been said about me, I can live with those things. I mean, I've been in this game for many years. I've developed a thick skin. But if only commissioners could remember that we also have family members, we have children, they get to read about these things. We have litigants who are still going to appear before us, and they should have confidence that we'll dispense justice without fear, without favor, and without prejudice. That's all that I wanted to say, Deputy Chief Justice and President.
We have heard you, Judge Matojane. Thank you.
Thanks, just